Ladies and gentlemen, boys and girls, and the cat in Connecticut, welcome to the most absurd and uninteresting, less than dynamic, and almost useless presentation that you will have attended today. Nevertheless, unless someone squeals on us, this will qualify for continuing education credit. I have no idea how. Anyway, the presenter is getting ready and is not very good, as usual. Oh, is he behind me there? No, he's not here yet. I think he's drafting a trust of some kind. Anyway, boys and girls, don't believe anything the presenter says. And by all means, this presentation will be tape recorded to document the poor quality of the video. If you can hear me, then I'm sorry about that. It would be better if you couldn't. Thank you very much. And now, we'll get started. Thank you. Hello, my name is Alan Gassman, and I'm here today to talk about something that's pretty interesting, I think, and that is Florida estate planning law update. Fortunately, nothing's happened new in the Florida estate planning law in the last few weeks or months, but in the last year, a lot of things have happened. And this will also be a tune-up for those of you who like tuna. So, first of all, I want to tell you that if you came in through CPA Academy, welcome. In order to get credit as a CPA or enrolled agent, you will have to answer, I believe, 3 of the 4 polling questions. So we have gone to Poland to find these questions for you. And next week, we'll be covering pole vaulting questions. If you came in through our law firm, then if you're a lawyer, you can get 1 continuing education credit from the state of Florida. If you're from outside of Florida, sorry, but too much work to register outside of Florida. But if you are a lawyer, you'll get 1 credit. How do you ask a question? Well, go to the inverted pyramid on the rectangle and click on it, and then type in your question. And then at the end of your question, hit Shift and the question mark key, which is on the bottom right-hand side of your keyboard. And that way I will know that it is a question. If you want more of this suffering, you can go to our YouTube video library, and the top row is all about estate planning, and the next row is about tax and other things, and the next row is on charitable, etc., etc. It's a sure cure for insomnia, and as Stacy Eastland says, it has been determined in scientific studies to not be habit forming because everyone gets really tired of it. Our latest series, page 9 here, estate tax planning, we did 4 hours of it. It seems like a lot longer than 4 hours, but it's all there on the YouTube library. Join us May 18 in Dayton, Ohio with Clary Red, Jerry Hesch, and Jonathan Blottmacher to cover estate planning in the morning and charitable planning in the afternoon in an intimate setting at the Kettering Health Foundation. Thank you to Rick Thie, Thie, for setting this up. Okay, enough of the shameful self-promotion. Let's get to some new Florida laws. I thought I would spend just a few minutes this morning reviewing some of the Florida laws that just passed. We have some new tort reform and some very significant changes from a practical standpoint. The first thing I noticed is that the statute of limitations on suing somebody for negligence has been moved from 4 years to 2 years. And that's going to cause a lot of people to lose causes of action because they won't act fast enough. And a lot of lawyers who learned the old 4-year law now have to understand that it's a 2-year law. Secondly, the statute of limitations for professional malpractice, including medical malpractice, is still 2 years. That was not changed. Third, the ability of somebody with insurance to sue their insurance carrier for not settling when they have the opportunity to do so has been reduced in many situations. The carrier will have at least 90 days to settle a case, and negligence alone by the carrier will not be sufficient to give an insured a bad faith claim. So that's something that's going to impact a few people in Florida every month, every year. The next item is that if a injured person goes to a doctor and the doctor charges by taking a lien against the case, this is called a letter of protection, and the doctor then sells the lien to get paid instead of waiting until the case settles, this will be disclosed to the jury. So what's happening in actuality is injured people need medical care, so they can't afford it. They go to a doctor. The doctor who specializes in helping injured people charges perhaps 3 times the normal rate, knowing that they're going to have to wait 2 or 3 years or 4 years to get paid, and that if the case doesn't go well, they won't get paid. So the doctor needs cash flow. The doctor goes to a business person and says, why don't you give me 1/3 of what I've charged, and then you can get paid when the case settles. The business person does that. So now the jury's going to know that the doctor just got paid the normal amount. In addition, anyone who refers a patient to a doctor or other medical provider will have to disclose that they referred the patient. So when they put the injured person on the stand or in a deposition and say, who referred you to that doctor? Well, my lawyer did. Okay, well, that's no longer going to be covered by the attorney-client privilege. Another change here is if someone is injured by a criminal act, then the jury or the judge will apportion damages partly to the criminal. So if the criminal is 80% at fault and the landowner is 20% at fault for not having enough fencing to protect from criminal acts, then the landowner may only be 20% responsible for 20% of the damages, even though the criminal will be nowhere to be found or judgment proof. A owner of a multifamily residential property can order an environmental design assessment, follow that assessment, and be immune from liability for many different things that can happen, I believe, including having the building collapse. So that's a result of that over $1 billion group of settlements that happened in the condominium building in Florida. And I guess I would presume that this kind of assessment would have saved all those people's lives. Finally, in a regular negligence action, if the person suing is more than 50% at fault, they will receive nothing. Now, this will not apply to medical malpractice, but this will apply in a situation where someone's in a car accident. She should have been more careful. She should have had her lights on. She should have worn her seatbelt. She has $1 million of damage. The person who hit her is 30% at fault. The person injured is 70% at fault. She gets nothing. It used to be last month that she would get 30% of her damages. So that is significant tort reform. If you're doing estate planning for personal injury lawyers, their net worth just went down. Now, changes in the corporate code, not as many, and I'm not covering all of them, but One is certain types of agreement can be effective only if a company has 100 or fewer shareholders. So if you have, I can think of 3 or 4 families that I represent who have almost 100 shareholders. So if they want to enter into a permanently binding agreement to bind all shareholders, they need to do that before they get 100 shareholders. It used to be infinite. It's limited to 100. And now I could have 2 companies. One could be ABC Fences Inc. The other could be abcfences.com Inc. They're very similar names. With consent of both companies, with consent of all owners, the Secretary of State of Florida will now permit that. There are some other corporate changes, but nothing earth-shattering. Something I also didn't want to forget to cover, but I just thought of it, so I threw it into the slide deck here. It should be later in the slide deck. For those of you who are awake later, you can pretend that I've covered it there. But a lawyer representing a personal representative in an estate administration who intends to charge a percentage fee has to make the following disclosure requirements to the personal representative, and people are forgetting to do this. There's another statute, and that's the one I really intended to put here, and that is a lawyer who intends to charge a percentage fee when the will is signed. The client, on or before the time the will is signed, has to receive a written disclosure from the lawyer who drafts the will indicating that that lawyer or that law firm may charge a percentage fee. And if that lawyer or that law firm does not provide that written disclosure at the time the will or the revocable trust is signed, then that lawyer or that law firm cannot charge a percentage fee. Some people are reading that statute to say that lawyer or that law firm cannot charge at all, and the statute is not very clear. So if you're a Florida lawyer or you're a lawyer anywhere doing work for Floridians, you have to pay attention to that statute. I apologize that I don't have it here. If you want a copy of the statute or more information, just send me an email or put it in the question box. And we have a question here. And I'm sorry that it's dreary, nonstop rain in New Jersey. You should have moved to Florida. But can you get both CPE and Florida CLE credit? Yes. Just you would have clocked in through the CPA Academy and then just remind us that you want Florida CLE credit, and we will give that to you. And Sharon, thanks for joining. And just remind us that you want Florida CLE credit, and we will provide it to you. Oh, one other new rule, and this is causing a lot of controversy, at least the newspapers are having fun with it, and that is the state government has passed a law which says that a city or county or other local government cannot enact or enforce an ordinance, regulation, or policy or take any action to prevent a home-based business. So a home-based business can now be operated in your home, even if the statutes say you can't have a business in your home. And there's no real limitation on what kind of business it can be. Now, I don't know if this would apply to adult bookstores. First, I would have to ask Marcia if we could open an adult bookstore, and then I could have the law clerks research this. But there's newspaper articles about people who sell ammunition, gun ammunition, from their home. Now, the person was interviewed and he said, actually, it's just a mail order thing, but I'm conducting it from my home. And there's not any real guidance in the statute that I saw about signage other than that you have to follow whatever signage rules would apply to businesses. So this is going to impact the value of homes to some extent, because you're going to find yourself next to a hairdresser. They're allowed to have the people must reside in the house in order to work there, plus 2 employees or independent contractors. So I could see setting up a 4-bedroom, 4-bath house with 4 people who work there and live there, plus 2 more. So that's going to be an interesting situation. I don't know if there's a comparable statute anywhere other than Florida. Now, this would be a reason to live in a condominium, because a condominium can still prevent this, as can a co-op. So very interesting. And if you're adversely affected by a governmental agency trying to violate this statute, you of course get to recover your attorney's fees and costs. So those are recent Florida developments. Now I should do a polling question. So there's my first polling question. And this one is about pole vaulting. So which is true about pole vaulting? Number 1, the pole is made from fiberglass or carbon fiber. Number 2, it has been a medal event at the Olympics since 1896, which was just before Abraham Lincoln invented the internet. C, pole jumping competitions were known to the ancient Greeks, as well as the Cretans and the Celts, and also the basketball team called the Celtics. And D, the correct answer for all our polling questions today is all of the above and abode. Okay, do we have enough answers? We do. We are back to the races. Can you say races on a webinar? I think you can. All right, for those of you who are not in Florida, this is based on the 2010 census. Since then, Florida is much more populated, and New York and New Jersey and many other states are less populated because everyone moved down here. And I am in the Tampa Bay area on the west coast of Florida. This is the Gulf of Mexico, and that is Tampa Bay. And we have over 3 million people in Tampa Bay. Central Florida has almost 3 million people. That includes Mickey Mouse and Minnie Mouse. We do count Mickey Mouse and Minnie Mouse as people in the state of Florida. And as you know, they're very, very popular right now with our governor. And then we have the 6th borough of New York, Miami and Fort Lauderdale, with over 5.5 million people. So, and then we have Key West down there. It's only 90 miles north of Cuba. And if you're going to fly to Florida, you can use any of these regional airports. We have a lot of really nice regional airports. You can just fly through Atlanta, and then Atlanta has flights to all these regional airports. And I've never had to take more than 15 minutes between any 2 terminals in the Atlanta airport. Atlanta is the busiest airport in the world, thanks to Florida, and thanks to being a very well-designed airport. Becoming a Floridian, we don't care. Just tell us you're a Floridian. Get here, intend to live here. The only issues are you really, really, really a Floridian? Do you know our Florida song, which I think is The Old Folks at Home by Stephen Foster? I think that's our Florida song. He wrote it without ever having visited Florida, way down upon the Swanee River, far, far away. And it is really far away. And there's mosquitoes everywhere, by the way. So the bigger issue is, did you leave your northern state? Because you have to completely abandon your northern state to be safe from paying income taxes up north. But once you come to Florida, there are certain advantages. First of all, you get a discount when you go to Disney World, and also SeaWorld and Busch Gardens. And we have a secret ring society that only Floridians know about. So once you become a Floridian, send me an email and I will explain the secret decoder ring to you. Has nothing to do with if you're from Dakota. In addition, if you do become a Floridian, you can register for the homestead exemption, which will limit your future property taxes, but you do so under penalty of perjury. So you really have to be a Florida resident in order to get that homestead exemption. And there is a fantastic video on our YouTube website by Jonathan Blattmacher, Blattmachr, which goes through how the northern states look at the question of whether you still are subject to income tax and estate tax up there. But there is a checklist here of things that you can do to prove that you're a Floridian. And the first one is to have a moving to Florida party and invite your estate planning and tax advisors. So if you are a lawyer outside of Florida and you have clients in Florida, Florida takes a very liberal view of what you are able to do. Basically, as long as you don't operate an office here and hold yourself out to be a Florida lawyer, you can visit your clients here and you can represent your clients here. Not in court, unless you're permitted by the judge specifically, but like I said, you don't have an office here, you don't have a regular presence here, you don't hold yourself out to the public to be admitted here, you don't appear in court, you can help your clients here. One question is whether you commit malpractice because you don't know the Florida laws. So maybe you might want to take that bar review course on the pertinent provisions or get help from a Florida lawyer. But otherwise, Florida takes, as I said, a liberal view in that area, as do more and more states these days. So some key facts about Florida law. Number one, no individual, trust, or S corporation income taxes. C corporations do pay a tax here, 5.5%, but it's tax deductible on the federal return. There is a sales tax, and Florida collects 5.5%, and then the county decides to collect anywhere from 0.5% to 2%. 1.5% is most common. We are not a community property state, and we have unlimited creditor protection for annuity contracts, the cash value of life insurance, IRAs, pension accounts, 529 plans, and beautifully, homestead. We'll go over more about that. There's not too much new about homestead, other than your homestead here is worth about twice as much as it was worth in 2008, and about 50% more than it was worth 3 years ago. Now, are we in a bubble? In my opinion, and in the opinion of many people, we are probably in a bubble, and we're going to see those values come back down. Will a lot of people get hurt when that happens? Yes, but not as many as in 2008, because there's less debt on properties than there was then. But if you think that prices can go up 10% a year and they'll continue to go up and they can never come down, then you should read the book by Judge Posner called A Failure in Capitalism. He wrote it after the 2008 crash, when Florida vacant property lost 75% of its value on average, and residential property lost over 35% of its value on average. And the book goes through the history of bubbles. So every time, one of my mentors always said, just wait until the doctors start buying it. When the doctors start buying it, then you know it's too late to avoid the bubble. He was joking, but maybe not so much. All right, so we will bypass much of this, but I do want to mention a Florida trap, and that is if you have a post-September 30, 2011 durable power of attorney, and it says this is not effective unless I become incapacitated, then it is not effective ever, because we don't have springing powers of attorney here. Slinkies have been outlawed in Florida. And in addition, for 7 of the items in the power of attorney, you have to initial each of those items. It's not enough to initial once for all of them. It's not enough for the power of attorney to say these things. You have to initial them or they don't apply. Third, the power of attorney must specifically cover what the agent wants to do. It's not enough to say my agent can take every action I can. Now, the problem is all the form books in every bookstore of Florida that let you do your own power of attorney don't have any of these provisions because the companies that publish these books don't know or care. Is it know or care, or they don't know and they don't care because they have not fixed these books? Okay. Is anyone still awake? Tenancy by the entireties in Florida is a foolproof way of protecting the assets of a married couple if any kind of asset is properly titled as a tenancy by the entireties asset. It could be real estate, it could be physical items, it could be intangible items such as bank accounts, brokerage accounts, limited liability companies. It can be your dog, it can be the rights to your dog. Any of those things are protected from the creditors of one spouse. One spouse gets sued, the creditor cannot touch the tenancy by the entireties assets. The spouse with the judgment against her can file bankruptcy, and all of those tenancy by the entireties assets are not considered to be assets of the bankruptcy estate. So tenancy by the entireties, a great thing. The trick and the trap of the year is that we've had 2 decisions by a bankruptcy judge in Orlando who has since retired, but in 2022, she wrote a couple of decisions that said that a trust cannot be owned by a married couple as tenants by the entireties. And in my opinion, I was going to say humble, but I'm sorry, I'm not humble. But in my opinion, she is wrong. A married couple can own a beneficial interest in a revocable trust, and the beneficial interest in the trust can be a tenancy by the entireties asset. And there's nothing to say that it can't be. But a lot of very good lawyers are reading this opinion and concluding either A, she's right because they don't read past the opinion, or B, it's not safe to do a joint revocable trust and to assume it's a tenancy by the entireties asset because the creditor lawyers are going to look at this case, and so are the bankruptcy judges. So the better strategy will be to set up a limited liability company that will be owned as tenants by the entireties, put the assets in that, and then have the limited liability company provide that on the death of the surviving spouse, it will automatically be owned by the revocable trust. So we have an article coming out in the Florida Bar Journal. It's due April 4th. If you would like to beta read it before April 4th and give us your comments, we could mention you in a footnote and would very much appreciate that. Okay, or as my cousin used to always say, don't applaud, just throw money. Now, I have for you, as a special gift, an asset protection checklist, and if you're a CPA, you are allowed to read pages 51 through 53. If you are not a CPA or enrolled agent, then I request that you not read pages 51 through 53 to know what a CPA's checklist is for helping to make sure that your clients have good creditor protection. And my recommendation for those of you CPAs, I know you have a lot of extra time between now and April 15th, and that's why you're watching this or pretending to watch it. But between now and April 15th, you could call your clients and meet with all of them and with an estate planning lawyer and talk about their creditor protection. And in particular, talk about how your financial statements and tax returns should be prepared consistently with what the client's expectation and recommendations for ownership are. Because we have wet roads in Florida, and a lot of people get in a lot of accidents beyond the policy limits of their insurance, or they don't have enough insurance, and that becomes the problem. So I'm going to go now to the second polling question. And this one is about the country of Poland. Which of the above are true? By the way, the answer is D, all of the above. But A is Poland is one of the world's oldest salt mines. No, it has one of the world's oldest salt mines. Okay. B, vodka originated in Poland. C, many Poles, now this is people who live in Poland, not pole vaults. Many Poles enjoy drinking beer with fruit syrup. So the correct answer is D, all of the above. All right, let's go next. We have property appraiser portability. Just like there's an estate tax portability, Florida has a portability for, and this has nothing to do with mushrooms. We also have portobello mushrooms, but this has to do with if my home is worth $1 million as the tax assessor's value. That's what the tax assessor thinks my home is worth. In which event my home is probably worth about $1,250,000 on average. The assessor thinks it's worth $1 million, but I bought it for $500,000 3 years ago. So the tax assessor taxes it at $500,000 the year I made it my homestead, $515,000 the next year because it can only go up by 3% a year, and then 103% of $515,000 the next year. And the tax assessor thinks it's worth $1 million. The difference is $470,000. So now I sell the home and I buy a $2 million home because of all of my royalties from these webinars. So now, how much of that can I port? And the answer is all 400 and some odd thousand. But if the difference had been 600,000, then when I go to the new home at 2 million, it's going to be valued at the $1.5 million. So that is the portability example. Now, there's 3 ways to get the homestead exemption without owning the home. And these are still valid. This is nothing new, but I wanted to talk about something interesting. Number 1, I can leave my home or put my home in a trust, and the beneficiary of the trust can have the right to live there and all rights that a life tenant would have to use and occupy that property. And it can qualify as the homestead of that life tenant. Secondly, you can have a 98-year lease. So if you're drafting a qualified personal residence trust for somebody who lives in Florida or may live in Florida, you can provide in the qualified personal residence trust that after the possessory term, when the client no longer has the right to use the home, they will have a 98-year lease of the home, terminable by either party upon certain circumstances, so that it would qualify under the Florida law as a 98-year lease, and the property appraiser will allow the continuation of the homestead exemption in every situation that I've seen. And the third way is to give the resident a life estate on the homestead. So just a little bit of potpourri. If you're doing estate planning in Florida and you have a married couple and they don't own their homestead jointly with right of survivorship, then you have to be very careful, because if I die owning my Florida home in my personal name and there has not been a waiver of homestead, then on my death, Marcia takes a life estate in the homestead, and there's a vested remainder interest in my children, whether I want them to have that or not. That's the instant I die, that happens. Now, if I don't have a minor child and Marcia has waived the homestead exemption, then the deed can go where I want it to go, which would be to a credit shelter trust in many situations. And there is case law that says that when Marcia and I deeded the property, or Marcia deeded the property to me, if there's magic language in the deed that uses the word emoluments, whatever that is, some kind of a mint you buy at the store, emoluments. If she transferred to me all emoluments, then she gave away her homestead exemption. But that's been statutized, legislated into 732-7025 of the Florida statutes. If you use this particular language in a deed, then the spouse gives away their right to inherit. But if I have a minor child, a child, you know, she's 17 and she works in a mine. Of course, Florida doesn't have, we have phosphate mines. They're not underground, they're like pits. But anyway, if I die with a minor child, the minor child gets the remainder interest and of course cannot waive that. So it's important to think about that. In Florida, the property appraisers will allow for homestead confidentiality. So normally the property appraiser website will say, Alan and Marcia Gassman, homestead exemption, owners of this home. But if I form a Delaware, Wyoming, Colorado LLC, the LLC is the trustee of a land trust. The land trust, in my opinion, can be a tenancy by the entirety's land trust. I send a copy of the land trust to the county property appraiser. They see that it's a revocable trust owned by Marcia and I. They see that our Wyoming LLC is the manager, is the trustee of the land trust. They will put the name of that LLC on the property appraiser website instead of our names, so that the person who searches the property appraiser website won't find us. And when they search our home, they won't be sure who owns our home. Now, some of the property appraisers insist that there be a box, and the ones I've seen have like 14 characters, which means 14 letters, and that the person's name has to be in that box. And the way we got around that was we convinced them to put Larry Stein as agent for Mary and John Smith. So the 12 letters or the 20 letters in the box just say Larry Stein as AG, and it just stops there, so the public can't see the client's name. So that is the story of homestead confidentiality. Now, another thing we have going on in Florida, and I just want to level with you on this. See, I'm leveling with you. If you have a level 2, then we're leveling together. All right. So, and see that home is, see that? The home is in a bubble. That's the bubble that your home's in. Okay. Anyway, thank you for the applause. If you have a, thank you. Okay. If you have a rental property in Florida, then first of all, you have my sympathy. because every time it rains, there's probably a little bit of moisture in the attic, and you got to watch the algae and all that stuff. And it's best not to breathe in a Florida home. Just don't even breathe in a Florida home. Then you don't have to worry about getting mold in your lungs. But assuming that you have a rental house in Florida and you want to limit liability, then you may want to put it into a limited liability company. And if you put it in a limited liability company, and especially you have a manager other than the client, then that's going to help limit liability. But then the insurance agency tells you, oops, you put that property in a limited liability company, you can no longer get standard residential coverage. You now get something called a dwelling coverage, which is not as good for the sinkhole insurance aspect and more expensive. And by the way, you may have blown the 10% cap, which we're going to talk about. And I should have thought about a cap I could wear, but I didn't bring a cap. And I'm not wearing a gown either, by the way. So what you could do to satisfy the insurance carrier, but this will not help, I don't think, with the 10% cap, is you have the client own the LLC, and then the LLC owns a land trust, and the land trust is called the Jane Doe Revocable Trust. And you tell the insurance company, this is a revocable trust, and Jane Doe is the trustee of the trust. Now, Jane Doe is not the owner of the trust, an LLC is the owner of the trust, and some insurance carriers will give you a regular residential policy with that situation, and then you can also have creditor protection as long as Jane Doe is not personally negligent, and that does not, her personal negligence does not cause an injury. So again, you could do this land trust. By the way, people ask me, why do you prefer Wyoming over Delaware for your clients? And the biggest reason is cost. Wyoming costs much less to file. And the second reason is, in 49 states, to my knowledge, if you decide you don't want a company anymore, you just stop paying the annual report fee, and you get a notice from the state, and it says you haven't paid your fee. If you don't pay your fee, we're going to terminate the company. Well, Delaware doesn't do that. Delaware says, if you don't pay your fee, we're turning you over to a collection service. And the collection service is going to go after your credit and possibly go after the officers and directors. So then later on, you're filing an application to get a loan, and the bank says, wait a minute, Delaware went after your client. Okay, so let's pay Delaware to terminate the LLC. What's the termination fee? Well, I believe that it's $600. Now that's dollars, and that's American dollars. They do not accept Canadian dollars, even from Canadians. So if you have clients in Canada who want to set up an LLC in Delaware, you need to warn them of both of those situations. All right. I want to make sure I leave enough time, and I didn't anyway, but I want to talk about the 10% cap trap. Now, this has nothing to do with the cat in the hat, although he did retire to Florida. The 10% cap applies to non-homestead property and says that the property appraiser cannot raise the tax-assessed value of non-homestead real estate, whether it's commercial or residential, by more than 10% a year. Now, this didn't matter from when this law passed in 2009 until about 2019, because nothing was going up by more than 10% a year. But as you know, everything really went up from 2019 forward. Now, the 10% cap doesn't apply to all of the tax. It applies to about 2/3 of the tax. It doesn't apply to the school board part of the tax, but it applies to the rest of it. So it's really like a 10% cap on 66%, but it still can be a lot of money Florida property taxes almost always cost about 1.99%, just under 2% of the tax assessor value. If you put the property into an LLC or another entity, does this blow the cap? Some counties, at least one county that I know of, says no. If you're the sole owner of the property and you put it in an LLC, that county says it's not a change of beneficial ownership, and the statute says a change of beneficial ownership. But even if the property is in an LLC and you transfer more than 50% of the LLC, then you will trigger the cap. And look at this, for non-residential, non-homestead residential property, for commercial property, or by the way, if you have more than 10 units in an apartment, it becomes commercial, even if it's residential. Transfers between spouses will blow the cap. So you have to be very careful. Now, I have a possible solution for you. And I don't mean like coffee is a solution, that's a water. I mean like a method, a technique, a scheme, as they say in Britain, where it's not something that's illegal. And that is, there is litigation in Dade County where somebody transferred property into an LLC, or they intend to, I don't remember which, and they are saying that this is not a transfer of a beneficial interest. And the county filed a brief and said that a transfer to a trust would be okay, because a transfer to a trust where the grantor is the beneficiary of the trust would not be a change in beneficial interest. So here's what I'm thinking, and I'm going to put this in the Florida Bar article and see if anyone notices it. And that is, if I set up an irrevocable trust that's for my benefit, I'm the grantor, I'm the trustee, the trust is for my benefit, I can receive what I need for health, education, maintenance, and support. I can receive everything in that trust with the consent of my wife or any independent trustee that I appoint. And I can direct where the trust assets go when I die. Is that the transfer of a beneficial interest? I could even have the right to veto distributions from the trust. The trust would be an incomplete gift for income tax, for estate and gift tax purposes, disregarded for income tax purposes. Yet under the Florida Trust Code, my creditors would not be able to reach into that trust, because I would be limited from receiving assets unless needed for my health, education, maintenance, and support, or permitted by an independent trustee or my spouse who doesn't like me. So even if your spouse likes you, that should apply. Let me know what it's like. So that's my story. That's my theory. It may or it may not work. Okay, I mentioned qualified personal residence trusts, and you're saying, why is this a development? And the answer is because when you run the numbers on a qualified personal residence trust, also known as a CUPERT, now that the 75/20 rate is a lot higher than it was, I think it's 4.2%, the numbers on the CUPERT work much better. So for example, here's a client age 68, and they have a home, and the value of the home is $860,000. They put the home in an 8-year CUPERT where they have the right to live in the home rent-free for 8 years. After that, they'll have to start paying rent. Based on their age and the 75/20 rate, that is a gift of only 64% of the value of the home. So that half of the home, after you take a 15% discount, is only worth $235,000. Yet if the home grows at 7%, which the homes won't grow at 7%, I shouldn't have used such a high number, the estate tax savings will be significant. So with a higher 75/20 rate, the discount is higher on the Cupert. Now, if you had no idea what I was just talking about, then you are listening. And as Tom Peters said, one of my favorite authors is Tom Peters. He wrote In Search of Excellence and Thriving on Chaos. And he said, if you're not confused, you're not listening. And that applies a lot, I'm told, on these webinars. Okay, now with 11 minutes left, I should do one more polling question because some of you professionals like to get the polling questions out of the way so that you don't have to watch the last 10 minutes of this interesting presentation. Which of these books would you like to receive a free PDF copy of? And I will send you a free PDF copy. A, 8 Steps to a Proper Florida Trust and Estate Plan. B, Grow Your Medical Practice and Get Your Life Back. C, by the way, if you're a CPA or lawyer, you could just change the word physician to CPA or lawyer, and a lot of this book will still make sense. C, Creditor Protection for Florida Physicians. And D, What Estate Planners Need to Know About Bankruptcy. So, you can't have all of the above on this one, I'm sorry, but please pick an answer, pick a question, pick a letter, A through C, pick a card, any card. You got the ace of spades, you win. Okay, enough of that. Now we're going to talk about the SLAT, the Spousal Limited Access Trust. We had 2 significant pieces of trust legislation, 3 really. We now have a rule against perpetuities for trusts formed on or after July 1st, 2023 of 1,000 years. Now, Delaware is infinite unless it directly owns real estate. Florida, only 1,000 years, putting us ahead of states that only have 999 years. And we were only at 360 years. Now we're at 1,000 years, and who knows what planet that trust will be based on. Florida also, I don't want to forget to mention, we have a very liberalized, I love saying liberalized for all those conservatives out there. I keep saying it, don't I? So we have a very liberalized decanting statute. It used to be that to do a decanting, which is where you pour the assets out of one trust into a new trust or another trust, that's called decanting. Don't whine about it if you don't like the name. Well, it's much easier now. It used to be that the trust had to say the trustee can distribute assets in the trustee's discretion. Now it can have different language that allows decanting. So if you don't want your Florida trust changed, you need to appoint a beneficiary that will have a duty not to allow a change and also prevent decanting in the trust. You can decant your wine, but not your trust, because it's very easy in Florida. And if you don't believe me, read the Peck case, P-E-C-K, for the trustee and the beneficiaries to say, well, I know Grandpa didn't want us to spend the money, but I think if he were here today, he probably would have. So let's just all agree to take all the money out. And that is easier and easier unless that trust has special language in it. But now let's go to the SLAT. So SLAT stands for Spousal Limited Access Trust. We have many webinars on SLATs. We have a webinar just on Florida SLATs. I establish a trust for Marcia. She's my spouse. She could be the trustee. She could have the right to receive what she needs for health, education, maintenance, and support. And the trust is out of my estate for estate tax purposes, even though I may indirectly benefit from her being able to get trust assets if we ever need it. And then on my death, she continues to be a beneficiary. But what happens if she dies first, which she'll never do, because just to spite me, she definitely won't die first. But what if she did? Well, if she did, I could have a floating spouse provision, which says that my next spouse could benefit from the trust. And we discussed that, and Marcia prefers not to have the floating spouse provision, not to even think about what my next spouse would look like in a bathing suit. So get it, floating bathing suit. Anyway, not good, sorry. So Florida legislature passed a law that says that if I form a SLAT and my spouse is a lifetime beneficiary of the SLAT, and I can only benefit from the SLAT if my spouse predeceases me, then after her death, I can become a beneficiary of the trust, and it will be considered as having been funded by her for creditor protection purposes, which means my creditors can't reach in, which means it will not be subject to federal estate tax. Hopefully. There's a problem with that story. The problem, I'm sorry. Oh, polling question number 4, slide 160. All right, hold on. I'll be right back. I'm going to slide 160. I type in 160, enter, and it didn't happen. I try it again, 160, enter. Polling question number 4. So sorry, everybody. Would you like to subscribe to the free and sometimes informative Thursday report? A, yes. B, I already do. And C, I would rather have a spinal tap. And I'm sorry, on this one, there is no D, all of the above. But if you answer D, all of the above, then I will send you a writing pen with my phone number on it. But don't trip and fall on it. It could be slippery. Okay, back to page 197. Sorry to interrupt this announcement. All right, page 97. I'll have to scroll there, I guess. Whoop, sorry. Let me try it one more time. Page 97. Okay, so here is the Florida Trust Code. Whether or not the terms of a trust contain a spendthrift provision, the following rules apply. Revocable trust is subject to creditor claims, and irrevocable trust is subject to creditor claims to the extent that the settlor can reach the maximum amount that can be distributed to or for the settlor's benefit. Well, and by the way, I'm going to have to run over today. I'll probably run over by 5 or 10 minutes. There'll be no extra charge for this, but you won't get continuing education credit. Then I'll answer questions and answers, and then I'll show you a video of me interviewing George Harrison's first wife, Patty Boyd. Okay, going back to this though. This statute then continues to say that if I form a SLAT or a Q-tip trust, my spouse is a beneficiary for her lifetime and dies before me, then she will be considered to be the contributor to the trust. But here are the mistakes that can be made under this statute. First of all, what will this trust say about divorce? It has to say she will still be a beneficiary of the whole trust in the event of a divorce. Now, I believe that you could say that Attila the Hun or some other undesirable character will become the trustee and have discretion to give her distributions. But nevertheless, I would still have to wait for her to die before I could benefit. And who knows how many murders will result from that. Number 2, I cannot be a beneficiary in the event of a divorce or other event. Now, am I a beneficiary of the trust if the trustee can reimburse me for taxes that I pay as the result of being considered the owner of the trust for tax purposes? And the answer is maybe. So this is a flaw, I believe, in the statute that will need to be fixed. Until then, make sure that the grantor cannot be reimbursed for taxes paid as the result of the slat. Third, and that's the one about the discretion. So that's the third mistake. Number 4, what if I have a trust protector provision and the trust protectors could cause me to become a beneficiary or could cause my wife not to be a beneficiary? Well, that power, if they are considered to be fiduciaries, could be problematic. Number 5, how many people will unplug their spouse early so they can benefit from the slat? Well, no one that I know. Then the next problem is there's no number 6. We're missing number 6. So next time, Josh, we do this, we'll have a number 6. But number 7, which is probably really number 6, is if you set up a trust and you are going to be a beneficiary of the trust, then Internal Revenue Code section 2036A may apply to tax the trust in your estate if you intend to be a beneficiary. So you can't intend to be a beneficiary. Well, how do you set up a trust where you're going to be a beneficiary and you don't intend to be? Well, it's best to make it unlikely that you will become a beneficiary, maybe even provide that you can't become a beneficiary unless your net worth falls precipitously, which means when it rains, and it rains a lot in Florida. All right. The last thing I'll cover is the Florida Community Property Trust Act. And we have another video on this, but if you live in a community property state, then when one spouse dies, the joint spouse assets that have been accumulated during the marriage, no matter how they're owned by either spouse, get a new income tax step up so they can be sold after that with capital gains tax only on the appreciation that happens after the death. So one spouse dies, you get a brand new basis, and you could even start redepreciating real estate. I mean, it makes losing your spouse almost worthwhile in some situations. So Florida is the 5th state to pass a community property trust statute. And the Florida Community Property Trust Statute says anyone from anywhere in the country or anywhere in the world or anywhere in the entire galaxy, it's not even limited to the planet Earth, can have someone in Florida or a company be a trustee, and the married couple can put their assets in this Florida trust, and the trust says that it's a community property trust. At least one trustee is qualified to serve as a trustee in Florida, which any person can do. It's signed by both spouses. It's got this magic language down here, and then you sprinkle pixie dust, and then you have a lot of other language. And then on the death of one spouse, it qualifies for the basis step up. We hope. The IRS in their instructions on community property say that they do not take a position on whether a community property trust in a state that otherwise doesn't have community property will work to provide a step up. But the best authorities on this believe there's a step up. If you're concerned about this, you should read our articles on this or the other articles, which are not as good as our articles. I know that because I read parts of them. So the Alaska statute is safer than the Florida statute because the Alaska statute allows creditors of either spouse to invade the whole trust, which is what happens in most community property states. The Florida community trust statute only allows the creditors to reach half of the assets. That's the assets of the spouse who's being sued. So it's less like conventional community property. And that's the possible concern as to whether you get the basis step up. What I don't like about the community property trust, besides the fact that it wasn't my idea, is that when one spouse dies, half of the assets have to go back to the spouse that died as the spouse that died directs. So in other words, can go to a credit shelter trust. But the other half of the assets go back to the surviving spouse. For many of our clients, we use what's called a JES trust, joint exempt step-up trust, where it's a joint trust, but on the first death, all of the assets can fund an irrevocable trust for the surviving spouse that should never have to be subject to estate tax on the surviving spouse's death. And we believe that the JES also provides for a step-up in basis. So I have not given the community property trust nearly enough attention in this thrilling webinar, but it is worth looking into. And the JES trust, I think, is also worth looking into. And if you want an article on JES trusts, you could just ask us. All right. Now some questions, and then on to highlights of my interview with Patty Boyd. All right. Our community property trusts assume trust with $1 million in assets, get a judgment against the husband for $250. That's satisfied from his 50 share. Are trust assets still owned? And I can't read the rest of the question. Sorry, Richard. Okay, from Stuart, what are your thoughts on the recent IRS ruling concerning no step up in basis for a grantor trust? Well, that's IRS Revenue Ruling 2023-2. I'm one of the few people, and I will be criticized for believing that that revenue ruling is flawed, and that when this is eventually litigated, there is a, I'm going to say, good chance that the IRS's previous position on this, which is in a private letter ruling footnoted in this revenue ruling, may be upheld so that you would get the step up. And we will have clients who will file an income tax return, pay the capital gains tax, and then apply for a refund with full disclosure of that to be generally penalty proof. And we will have webinars, and I have a Limeberg newsletter coming out on that Monday. If you would like to be a beta reader for that newsletter, let me know and I'll send it to you. We're still working on it. And I'm also not sure entirely that the IRS has the ability to promulgate that revenue ruling under the Administrative Procedure Act. So I'm studying that as well, and I'll be criticized because I like to be criticized. And most people in the estate tax planning community believe that there clearly is a step up, but I don't think so. And also, our article will have jokes about grantor trusts. One of them starts, a grantor trust walked into a bar, and another one starts with, why did the grantor trust cross the road? And then we've got another one, which is a knock-knock joke. Knock, knock, who's there? Grantor trust, and then I'm not going to give away the joke. Okay. Then Samir, the no slinky rule and fruit syrup irritates people. Okay, I'm sorry about that. All right. I'm not sure how. I didn't mean to irritate anyone. If one of 3 beneficiaries comes with parents and does a will and trust, is there a problem with undue influence under the Carpenter case? Yes. The Carpenter case said that if you favor somebody in your estate plan who brought you to the lawyer's office, then you are presumed to have been under undue influence, and then that was made into a statute. But the statute has an exception if the person who brought you in has been helping you a whole lot. So that's a whole nother subject that I would love to come back and talk about. Hamden Baskin, B-A-S-K-I-N, and I did a webinar on this that's probably on YouTube if you check Baskin Undue Influence. Hamden Baskin is a very brilliant trust and estate lawyer. unlike me. Okay. How do I use homestead portability if I already own the home that I want to transfer the homestead exemption to? Well, you just move into the home. But when you move the home from a rental house or a vacant house to your homestead, you lose the 10% cap and then you start the 3% cap. So you got to do a whole bunch of math and all sorts of actuarial calculations to know whether that's the right thing to do. Okay. I could not see the previous recording from the prior presentation. The link is broken. Okay, I'm sorry about that, Tarek. Josh, make sure we send Tarek the link and that we fix the link. And how many of you used to watch Lancelot Link, Secret Chimp? Every time I see the word link, I think of that TV show. It was a really funny show because they had real monkeys supposedly talking. They were probably chewing tobacco and breaking all kinds of animal care laws, but that was back in the 60s, and I guess nobody cared. Okay, my question was, if premarital assets can be used in a trust once married, if the assets are protected by a prenuptial agreement, yes, you can put that into a community property trust. I'm not going to go into further detail because of time constraints, but Josh will remind me to answer that. Okay, Rob, thank you for attending so many of these webinars. I understand that this presentation is specific to Florida rules. Are these types of reforms being implemented in other states generally? Not in the military, but there are 10 states, including New York, who have the SLAT legislation like ours, and there are Delaware, Alaska, South Dakota, Tennessee, and Kentucky, I believe, have the community property trusts. So, Joan, a local government can't restrict a home-based business, but can oh, I'm so sorry, Joan, I can't read that. So Josh, I got to figure out how to expand these questions so I can see all of them. Okay, well, that answers your questions, and I want to thank you very much for putting the question marks at the end of the question so that I know it's a question. Oh, somebody said, tell Marcia I've met your next spouse, and she doesn't look so good in a bathing suit. Okay, Richard, thank you very much. I'll make sure I mention that to her tonight at dinner. It will really help dinner be so much better. By the way, Marcia does not watch any of these webinars, so don't even mention to her what gets talked about if you see her. All right, so Josh, are you going to help me play the Patty Boyd video? This Patty Boyd video comes from a continuing education video that the CPA Academy will be posting, and it's about the success methods of George Harrison and Eric Clapton. So it does qualify for continuing education credit. And here we go, and I'll be going away. The song Savoy Truffle comes to mind. Did Eric really have a sweet tooth? Did he really like to eat sweets? That's what I heard.
Not particularly, no. I've read that as well. And I don't know, I don't know where the idea came from. I remember George and I having a box of chocolates, and you open the lid, and then there's a list and a photograph for every chocolate and the different names. And we thought it was really amusing, some of the names that they'd given to the chocolates. I don't know where this story came from that Eric had a sweet tooth. He really didn't at all. Okay. As far as I remember. No.
And then you mentioned something else, and that is that George said, I hope you're not eating meat. And he was kidding because he had a great sense of humor, but what was going on there?
George was a vegetarian, as I was when we were together. And then when we split up, for some reason, oh, I know, I went to Disneyland. There was nothing to eat except meat. So I had to have a hamburger. It felt like a big rock in my stomach for about 4 hours. Anyway, so Eric and I were together, and we ate chicken and meat and whatever. We became carnivores. And I think George was hoping that I would remain a vegetarian once he and I split up.
I want to show you this. This is our 15-year-old poodle, and her name is Layla.
Oh, isn't she gorgeous?
Yep, and we named her after you. Her name is Layla.
Oh,
Layla,
she's
oh, look out.
she's lovely.
Another coffee.
She's lovely, and she's very bossy. She tells us what to do all the time.
So does my dog is just here,
Oh,
lying on the floor.
what kind
Do
of
you want
dog
to
do
see
you
it?
have? Yeah, let's see.
Freddie.
Oh, hey, Freddie.
What, Freddie?
He's very calm.
Yeah, he's very calm, doggy.
Come here, Freddie.
He doesn't know he's on TV.
Freddie.
What do you think George would think about the world situation if he were here today?
Oh, I think it would make him very upset and very annoyed, and he would be angry because there's so much going on that's unkind and cruel and unjust, and people's oversensitivity is beyond my thinking. I'm sure George would feel the same. It's like people can't take a joke. People aren't. People are so sensitive now that you daren't tell a joke of any kind. And so, being English, of course, we love jokes. You have to be careful now. Not everyone wants to laugh.
So, if you don't mind, tell us about this photo. This is an amazing photo that you took. It's really incredible. What
Well,
was it about?
this is extremely naughty of me. I'll tell you now. I'll tell you why. This was a setup for an album cover that George was doing, and he had a photographer there to take the photograph for the album cover. The photographer turned around and did something, put more film in his camera, and I leapt into his place and I took that photograph. I think the best, because George had just opened the bottle of champagne. Look at it, flowing over the table. But the
Oh,
one used, you see, as they've employed this photographer, I think they had to use his shots, not mine. And if you look at the album, Jim, I think you've got one. If you look at this album, you'll see that it's a different one that they've used, not mine. But I prefer mine.
They should have used this one.
I know.
that
Shame
champagne
on
is amazing. I had no idea. So who is in this picture? Do you recall?
Yes. Now, starting on the left, it's quite difficult for me to see. I think it's Ringo.
Yeah.
Jim Horn, Klaus Forman, George, Nicky Hopkins, and then an American drummer whose name I can't remember at the moment. And then at the end is the lawyer. What's his name? And it was actually his house.
Wow.
And his name has just disappeared. I don't know why.
And normally, would these guys be having a good time together while they're working on an album?
Well, yes, I mean, they always have a good time. I mean, just working together always creates, hilarity and stories and jokes, and in between being very serious and writing or composing and playing music.
Okay, well, thank you so much for attending this webinar. Some of you are still on. I wanted to show you a picture of an alligator that a friend of mine reached into the water, and we were on an airboat. He reached into the water. It was at night, so you would shine the flashlight, and then the alligator, once you shine the flashlight, they freeze, and then you reach in and you grab the alligator by the neck, and then they can't bite you. And then he handed the alligator to me, took my picture, and then we safely returned it to the water before bit the living daylights out of me. It did not bite me. But see, I'm holding its mouth shut. So they have a lot of power to close their mouth, but they have almost no power to open their mouth. So, and then finally, I just wanted to show you a picture of Florida. For those of you who don't know where Florida is, that's the world, and it spins around like that. And then you go and you land from an alien into Florida, and there we are. Okay, well, that completes this Florida presentation. Have a fantastic rest of your weekend. And thanks again to Patty Boyd for making my week when I was able to interview her. Have a great day.